this installment of Washington Legal Foundation's Legally Brief, we are joined by Keller and Heckman partner Sheila Millar, who will share some thoughts on consumer class action lawsuits involving food labeling and advertising. Sheila, is it safe to say that class action suits alleging false or misleading statements by food companies on their package labeling or promotional materials are on the rise, and if so, why?
I think it is fair to say that there's been an uptick in all sorts of marketing-related class action lawsuits, from privacy to advertising, and certainly the food industry has had its fair share. Many of those suits are focused on health claims and claims like natural. I think in terms of what are the reasons, as with anything else, it's probably a series of reasons. One would be, I think, the interplay between regulatory activities like Food and Drug Administration warning letters, Federal Trade Commission consent agreements, and also National Advertising Division decisions. Those tend to trigger follow-on class action suits sometimes. I think another reason is the general focus on a litigation agenda from some of the NGO activists. Now, that agenda is largely associated with their obesity concerns and attempting to seek changes in the advertising landscape to respond to concerns about obesity. But that general discussion of advertising litigation as a tool, I think, has an impact in the broader marketplace of class action lawsuits. And then perhaps another rationale or reason is the decline in some of the mass tort lawsuits. We've certainly seen a decline in asbestos and tobacco claims, and certainly that leaves a number of plaintiffs' attorneys looking at areas for new litigation opportunities as plaintiffs' lawyers.
You mentioned these suits involving the term natural or all natural. What do you think the implications of these particular charges are, and is there any kind of a role for federal regulators in creating more uniformity about what these terms mean?
Yes, I think certainly the example of the lawsuits, the class action lawsuits against Frito-Lay and PepsiCo, consolidated, I think, just this week in New York State, are a case in point. The plaintiffs were alleging that the natural claims violated false advertising standards because the corn chips were derived from GMO or genetically modified organisms, and they alleged that that's false and misleading. In the context of the relationship between regulatory arenas, we look at the FDA's guidance on natural, and the FDA has certainly issued warning letters saying that natural means that nothing artificial should be included in the food that would be contrary to customers' expectations. And that issue of what does nothing mean, I think, is an important legal issue. Certainly even at FDA, natural products can have pesticide residues that meet FDA tolerances. And in other contexts, let's talk about environmental marketing claims, for example. Both the Federal Trade Commission and the NAD have said that in terms of a free of claim, a product is free of lead or BPA or anything else you might name, can still have a de minimis amount of that material and be free of, and that claim is not necessarily false and misleading. When we think about the assertion that GMO-based materials are inherently not natural because you're introducing a trait that's not known in nature, let's think about a stalk of corn that's GMO modified to be pesticide resistant, and a stalk of corn that's treated with a pesticide. If it's nutritionally and organoleptically identical to consumers, I think there is a really interesting question about, are they the same? Wouldn't consumers understand them as the same? If you pose that leading question about, do you think a GMO material is different, I suspect we know what the answer would be. But that may not be the right way to pose the question to consumers. You asked about what is the role for government standards, and there may be a role, and obviously that depends on what the standards ultimately are. If we think about the analogous organic standards at the U.S. Department of Agriculture, we do accommodate some de minimis amount of non-organic matter and still allow a product to be called organic. So the devil is in the details, and the impact on the marketplace of standards depends actually on what the content of the standards might be. But certainly uniformity in standards could allow for legal preemption arguments and standardize the marketplace to whatever the requirements might be.
Now, as an attorney who specializes in keeping your clients out of these types of suits, what 2 or 3 things do you usually look at when food companies are designing labels and advertising campaigns to keep them out of these kinds of suits?
Well, obviously, you look at the FDA and FTC requirements, but you also look at substantiation. Substantiation is the key for any type of advertising claim. If without substantiation, you really don't have a legitimate claim if that claim involves a trait that is material to a consumer, meaning it's likely to be relied upon in making a purchasing decision. And that's true whether it's a health claim or a natural claim or an environmental benefit claim or a weight loss claim or any other type of claim. I think what's a little bit different now is stems from the Federal Trade Commission's activities somewhat recently in looking at health claims in particular, requiring in certain instances that companies seek FDA approval for health claims or provide substantiation in the form of 2 human clinical trials. So this type of substantiation, we support substantiation. It's a necessary requisite for confidence in the marketplace. But whether that degree of specificity in mandated substantiation is necessary, I think remains something of an open question. But certainly as lawyers, we look to those types of guidance from the agencies, even when our clients aren't named in those types of consent agreements, because it may have that type of precedential value. But as I said, I think the key is to make sure that you work collaboratively with your clients, both on the technical side, on the R&D side, and on the marketing side, so that you come up with creative and impactful advertising campaigns that also meet the letter and the spirit of the law and are truthful and not misleading to consumers.